Ready, start. A landlady had rented out her flat situated at Bandra in Bombay to a tenant in 1969 for a rent of rupees 200 per month. Full stop. As years passed by, she found it difficult to accommodate her large family in the small residential apartment where she is presently living. Full stop. So, she moved the court in 1977 for a decree of eviction of her tenant from her flat at Bandra. Full stop. Of course, she cast the net very wide, covering a variety of grounds to have a decree for eviction, but what ultimately survived among them was the ground envisaged in section 13 within bracket 1 within bracket G of the Bombay Rents, Hotel and Lodging House Rates Control Act, 1947, that is bona fide and reasonable requirement of the tenanted premises for her own occupation. Full stop. Though, she was non-suited by the trial court, she went in appeal to the appellate bench of the court of small causes, where she got a decree for eviction on the ground mentioned above. Full stop. But the said decree did not inure to her benefit, as the same was later upset by the High Court of Bombay when the tenant filed a writ petition under Article 227 of the Constitution for quashment of the same. Full stop. This appeal, by special leave, has been filed by the landlady impugning the aforesaid judgment of the Bombay High Court. Full stop. It is to be pointed out that need of the landlady for additional accommodation in view of her large family was recognized by the trial court. Full stop. Still, she was non-suited by the trial court on the premise that her pleadings on that score were scanty. Full stop. Appeal court, after concurring with the finding which was favorable to the landlady, did not take the inadequacy in the pleadings as capable of fatally affecting her cause. Full stop. Hence, the appeal court found no hurdle in granting the decree of eviction. Full stop. But a learned single judge of the High Court held the landlady guilty of two wrongs. Full stop. First is that she did not speak the truth in her evidence that her eldest son has his own flat where he is living with his family. Full stop. Second is that, she failed to specify the plinth area of the apartment in which she is presently living with her family. Full stop. According to us, the High Court has traversed far beyond the limit of its supervisory jurisdiction under Article 227 of the Constitution when the learned single judge reversed the decree of eviction, which was based on findings of facts arrived at by the fact-finding authority upon the evidence on record. Full stop. It would have been well for the High Court to remind itself that it was not exercising certiorari jurisdiction under Article 226 of the Constitution, but a supervisory jurisdiction under Article 227, which obliges the High Court to confine to the scrutiny of records and proceedings of the lower tribunal. Full stop. By relying on fresh materials which were not before the tribunal, the High Court should not have disturbed the findings of facts in exercise of such supervisory jurisdiction. Full stop.